record this. And we have attendees. Okay.
You can wait a few minutes.
Yes, because we need to wait till everybody is able to log in to our webinar. Okay. So it's 10:03. I think we can start our webinar. So good morning, everyone. On behalf of the Court of Arbitration at the PCC and Director General Agnieszka Durling and IFM Below 40, my co-chairs Anna Tujakowska and Konrad Czech, I would like to welcome you to our today's webinar session about virtual hearing in the arbitration. Before I give the floor to Konrad to introduce our guests, I would like to take just a few seconds to share with you some housekeeping updates. First of all, we would love to have your questions. So don't feel free, use Q&A button to ask the questions, and the panelists will answer it after their presentations. Secondly, the webinar is recorded, so it will be available on demand, and so you can come back to the content after the webinar. And last but not least, we are going to launch the poll after the webinar, anonymous poll with 3 simple choice questions. And the report of the polling will be available after webinar too. So I'm very welcome. And now I hand you over to Konrad to introduce our panelists.
Okay, thank you very much. Good morning to everyone. A very warm welcome to all of you at this virtual meeting of AFM. I hope that you are all staying safe and well during this crazy time. And thank you for joining us with your morning cups of coffee. The ladies, I mean, Agnieszka and Anya, have asked me not only to open this webinar, or actually Agnieszka has just opened it, but they also asked me to introduce our guests. So let me tell you a little bit about our speakers who will share their recent experiences with online hearings with us. Our first guest is Christopher Chin. Christopher is a cosmopolitan lawyer, admitted in a number of jurisdictions, including England and Wales, New York, France, and he's based in Paris, where he runs his own arbitration boutique. Christopher has been involved in international arbitration since the late 1990s, so for quite a few years, Chris. And he was raised in Hawaii or Hawaii. How should I pronounce it, Chris? Hawaii. Okay. This is I guess the pronunciation in the local Hawaiian language. He studied history at Yale and then law at the University of Minnesota. He speaks English, French, and apparently Polish, but I don't believe it.
To nieprawda, nieprawda.
Nieprawda. Okay, perfect. I just wanted to check. Anyway, I know that his partner is Polish, and bearing in mind how influential are Polish women, I can bet that he speaks some Polish. Let me move to our second speaker. Our second guest is Jörn Hombeck from Hannefeld legal. Jörn primarily acts as counsel in German state courts and in arbitration proceedings. He also frequently acts as arbitrator. As far as I know, he focuses on construction disputes and renewable energy disputes. He graduated from the University of Auckland in New Zealand, where he earned his LLM degree. When our paths crossed for the first time a couple of years ago, Jörn was an aspiring senior associate at Hannafelt Legal, where I was interning. Since that time, he has been promoted to partnership at Hannafelt, so now he's an established practitioner in Germany, and I have changed my employers twice and eventually ended up law teaching. Just kidding. I love explaining to students basic principles of arbitration. So no, Jörn, I'm not jealous at all. Having introduced our speakers, Christopher, the floor is yours, or actually the microphone and the screen is yours.
Okay, thank you. Thank you, Agnieszka and Konrad. Thank you to the SAKIG court and to the AFM Young Arbitration Forum. I will begin by saying a few words about the topic of today's webinar, which is virtual hearings in arbitration. And I wanted to start by backing up and defining what is a hearing, and why is a hearing so important in an arbitration. There are two different categories of hearings in arbitration. One is a procedural hearing, a procedural meeting, where the parties establish the calendar of the proceedings and they discuss housekeeping and daily business with the tribunal. And at least since I've been practicing for the past 20 years or so, this initial hearing has usually been by telephone or by video conference if the parties or the counsel are in different locations. On the other hand, in arbitration, you have the hearing, which is a bit different than in the civil courts, at least that we have here in France, and also I understand in Poland, where there has been a lot of influence of the common law jurisdictions in arbitration hearings. And a lot of the hearing, the purpose of the hearing is to establish in transcription form witness testimony that the counsel of both parties can then test during the hearing. So it's an opportunity to establish evidence that otherwise would not have been available in the case. You've seen on television shows, maybe Anglo-Saxon shows, particularly in the United States, where I'm from, where witnesses get attacked with questions, and sometimes they break down during the hearing. That doesn't usually happen, but what the transcript does is it establishes in writing what the witness's testimony will be, so that the parties can then use that written evidence in further arguments. And of course, it also helps the arbitral tribunal understand the case more, so that the case comes alive for them. And this has, in hearings, arbitration has always been flexible as in respect of where hearings occur. So we have the words of Redfern and Hunter 5 years before COVID started, where it says, subject to any mandatory provisions of law in the seat of arbitration, there's generally no requirement that that the hearing has to take place in the legal seat where the arbitration is occurring. So in arbitration, when we talk about well, what is the place of arbitration? What is the seat of arbitration? I'm having an arbitration in Poland or in France. The seat, when we talk about seat or place of arbitration, it means the country whose legal laws apply. It doesn't mean where hearings take place. And this is especially useful, it's always been useful for international parties, so that parties don't have to travel to the country of their adversary. They can choose a neutral place of meeting. They can meet where the witnesses might be located. They can meet wherever it's convenient. And one interesting question to think about is, where do virtual hearings take place? We have, some of you may have heard the term hybrid virtual hearing that's been talked about, especially since COVID has forced a lot of hearings to go virtual. A hybrid hearing is where some of the participants are together physically, like in a traditional hearing, but others are participating remotely. So in this webinar, this is actually a hybrid webinar, because we have, you see in the picture below, you have the secretariat at the Court of Arbitration at the Polish Chamber of Commerce in Warsaw, SAKIG. You see that the participants are there live together, but I'm participating from Paris. John is participating from Germany, and Anna is participating from her office in Warsaw. So what's the legal basis to have a hearing, to have hearings in the first place? And also, how can we have hearings virtually? What is the legal basis for that? In the Polish Arbitration Act, it doesn't say whether hearings can be held virtually or not, but all it says is the parties have to be treated equally, that there's due process. And the Polish Arbitration Act gives a lot of discretion to the tribunal in any manner that it considers appropriate, at any place it considers appropriate for its deliberations. Now, a clever lawyer might challenge the Polish word for place. I think it has to do with miejscu, or it's a physical. It's in the physical sense, but it could also mean in a virtual sense, or I guess you could say that a virtual hearing does take place physically. It just takes place physically in two places at once. So question whether a virtual hearing is legal under the Polish Arbitration Act. Most practitioners would say it most certainly is. And it's de facto legal. Otherwise, you would have hundreds of proceedings that would have been invalidated by now. The SAKIG rules of the Court of Arbitration echo the Polish Arbitration Act, where they give broad discretion to the tribunal. The tribunal shall conduct the proceeding as it deems proper. You just have to have equal treatment of the parties, and each party has to be heard. And in fact, the tribunal must ensure that the proceedings are speedy and efficient. And of course, one of the advantages of virtual hearings is that they're speedy and efficient. The International Council for Commercial Arbitration, ICA, which is an association of arbitration practitioners, launched a research project in the summer of last year at the height of COVID, and I guess we're at a new height right now, where virtual hearings are necessary in international cases. They phrase the question as follows: does a right to a physical hearing exist in international arbitration? So in other words, if a party insists on having a physical hearing, can they do so despite what the tribunal may say, or despite what the other party may say? So far, about 22 jurisdictions have responded. We can expect that Poland will be in the next tranche of jurisdictions to reply next month. So far, there has been no explicit right to physical hearing in the legislation of these states. But there's a whole bunch of complicated issues that have arisen. For instance, if the parties provide for a type of procedural hearing, does the tribunal have to accept that or not? And in some jurisdictions, it actually depends on whether the parties agreed to the procedure before the arbitration tribunal was constituted or afterwards. And I haven't looked at that question, but I guess it would have to do with sort of the idea that it's contractual in some ways, that when the tribunal agrees to an arbitration, certain basic rules may be locked in so that the parties can't overrule the tribunal. And you see that explicitly in the SACIG Court of Arbitration rules. The parties cannot agree to pay the arbitrator $1 for his or her services. There's certain things that the parties cannot agree on against what the tribunal may say. Challenges to virtual hearings. The idea of having a virtual hearing has been challenged, as you may imagine, in most jurisdictions, since especially since COVID restrictions have forced hearings to go virtual. One interesting case that I read about was the ICSID investor state case, where Spain, on the basis mostly of bias and dishonesty on the part of the tribunal, allegations of bias and dishonesty, said that basically the tribunal's fixing of a virtual hearing, contrary to what had been agreed before COVID-19, that this was grounds to have the tribunal dismissed, because the tribunal had fixed a virtual hearing and thereby showed its bias against Spain. Among other arguments, Spain said that only an in-person hearing with all members of the tribunal would be able to guarantee procedural equality in this particular case. So the decision went to the ICSID Administrative Council, and you can look at the award, the decision online, where the Administrative Council dismissed this objection of Spain and said that basically the tribunal had not acted grossly unfairly or demonstrated bias, and that also it's the tribunal that is best placed to sort of weigh whether or not a virtual hearing and under what circumstances a virtual hearing should occur. So that's what one might expect of a tribunal in a case where the tribunal is acting fairly and it isn't using a virtual hearing to strip one of the parties of their procedural rights. That's it for my presentation, and I look forward to the question and answer session later. Thank you.
Okay, thank you very much, Christopher. And now I guess it's Jörn's turn. Jörn?
Yes, I will also just start my split screen screen sharing. Just a second. Okay, I hope you all see now my slides. First of all, thank you very much to the organizers for this fantastic opportunity, and to Chin for the excellent basis that I can now go on a bit with some personal experience and which has recently maybe been discussed about virtual hearings. As Chris already pointed out, virtual hearings are not an entirely new thing in arbitration. But of course, due to the pandemic, the attention for this topic has increased significantly. And from a legal perspective, it's still a rather new topic, and there are many issues or questions where we don't have a definite answer yet. So what I will say today is not to be understood as the perfect solution, but rather as some food for thought. But as Chris already mentioned, the procedural hearings, they have for quite a while been virtual in most cases. And one of my first arbitrator appointments, which is already a couple of years ago now, that was, you could call it a hybrid hearing because we as a tribunal sat together in one room, but both parties were represented virtually in that hearing, and that was years before COVID. So I think the new issue is the amount of virtual hearings and the question that Chris raised at the end, whether tribunals can order a virtual hearing against the explicit will of one party, because before the pandemic, all virtual or hybrid hearings that I have heard of was in the mutual agreement of the parties, and usually in rather small cases. I think what we all can say is that virtual hearings definitely offer some real upsides for the parties. I will address a few of them on the next slide, but there are still legal uncertainties and other rather new pitfalls. Regarding the latter, I think most of you have by now seen the video or at least heard of it, from which I took the picture on this slide. That was not in an arbitration, but in a US litigation. And in such case, the one lawyer was unable to switch off the cat filter that someone had activated on his Zoom account. And so he appeared in that virtual hearing as a cat and struggled for a couple of minutes to switch that filter off. And at some point, he told the judge explicitly, "I'm not a cat." So this is not my personal experience with pitfalls. And it is rather an extreme example, but it made it to the non-legal news, and therefore maybe made the topic much more known to the outside world than it was before. And maybe the organizers already expected something like that, because they approached us with the idea of this hearing before this video emerged. So I think we are really talking about a very hot topic in international arbitration and in general at the moment. Possible upsides of virtual hearings, and there has already been said a lot on it, and I think we can agree on most of it. It's a virtual hearing will save travel cost, it will save time from travel, and it will reduce the ecological footprint that international arbitrations tend to have. I have just slightly modified an example of a case I had recently, where the arbitration was based or seated in Switzerland. The parties came from Tunisia and Germany. They had counsel from France, Germany, and Switzerland, and the arbitrators were from Belgium, Egypt, and Austria. If you imagine to have a physical hearing in that case, there would be a lot of traveling, and this does not even include witnesses who sometimes can live or work in, again, other countries, and therefore contribute to the travel necessities. It is also quite often said that a virtual hearing saves time, and I do agree with it in principle, because it saves travel time, and for example, particular short hearings, it is far easier to find a schedule for the hearing with busy lawyers and busy arbitrators, because they only have to find a slot in their calendars for the hearing itself and not for travel time and some buffer times. But I have now had a hearing, a virtual one, with participants from the US, and there at least you have to think about whether it really saves time, because due to the different time zones, it was really an issue to agree on the time slot for that hearing? Because can it be requested from one party to have the hearing during their night shifts? Is it like US and Germany, it was still only 8 hours. So we started at our lunchtime and ended in our evening. So the US started very early and we started quite late. But for example, if you have Australia and Germany with 10 hours of time difference, what do you do? Do you do short hearing slots that both parties somehow work within their regular daytime? But then if you only have 5 hours of overlapping daytime, then you have only 5 hours for hearing per day. That can require quite long hearings if you usually would have 10 hours of a hearing per day. So that is only one thought that came to my mind, whether it's really saving time when you have different time zones, or whether in such cases everyone traveling to one at least time zone and then doing full day hearings is maybe in fact also saving time. It for sure saves other expenses that you have in physical hearings. It is rental fee for the hearing location, for catering, potentially for court reporting, because it is my experience that at least in smaller cases, the parties agree on simply recording the virtual hearing, as this webinar is recorded as well, and therefore not having additional court reporters, which can be quite costly. So these are definitely upsides of virtual hearings, and my personal experience is that they usually work very well if all parties want them to work well. And that is one of the possible downsides I will address on the next slide. They are, due to uncertainties, potentially more vulnerable to against guerrilla tactics, and therefore they don't necessarily work well. As Chris already mentioned, the point of whether there is a right to a physical hearing. This is maybe the largest uncertainty so far, that in most jurisdictions, there is no case law yet on the question whether a tribunal can order a virtual hearing against the will of one party. And I think we all have to be clear, it is not an issue if both parties agree to a virtual hearing. And I think it would have been, or it is almost certain that an arbitrator should not order a virtual hearing if both parties agree not to have one. So we only talk about the case that one party and the tribunal wants to have a virtual hearing, and one party objects to it. And Chris already mentioned the exit decision. It was not straight on the question of whether an award can be set aside for it, but that it was not a ground for challenging the arbitrators. The Austrian Supreme Court did render a decision that, at least in principle, it is not a reason to challenge an award based on based on having a virtual hearing against the will of one party. But there's still many major jurisdictions where we don't have such case law. And I have to be honest, from what German courts do, or most German courts do in litigation with regard to virtual hearing and how reluctant they are on that, I would not bet on the outcome of a challenge to an award before German courts, simply for the tribunal having ordered to have the virtual hearing. Another point that was addressed in a couple of seminars in Germany during the last month, which has, to my knowledge, not been before courts yet, is data protection law. There are a couple of data protection specialists who question the compliance of many platforms used for virtual hearings with EU data protection. And some even say the parties cannot even overcome these issues by consent. But I honestly, I don't have a solution for it, but I would say you should at least try to seek consent by all parties and all witnesses, so everyone participating in the virtual hearing, also with regard to data protection, because if you would force someone to participate in a virtual hearing or against explicit objections for data protection, that could also be another reason for setting aside the award. And the last bullet is about equal treatment. This is, for example, the case when one party has connection problems during the hearing. Can it be requested to continue? Can this party be requested to continue via phone? Or would this be a violation of equal treatment if the other party is still connected via video? So is it an equal treatment if one party sees and is seen the others during the hearing, while the other is only hearing the hearing? And if so, is it still okay if that is caused by connection failures of that party? Again, I don't have an answer, but it is a thing you, and particularly if you sit as an arbitrator, should consider how to deal with such a situation. And then the last point, which I already mentioned, is that these legal uncertainties can make virtual hearings more vulnerable against guerrilla tactics. And don't get me wrong, there can be very valid reasons to object against a virtual hearing in any given case, but the existence of uncertainties and the lack of reliable case law make it quite easy for a party that wants to jeopardize the proceedings to raise objections caused by these uncertainties, and then kind of see whether the arbitrators are reluctant to face the risk that their award will be challenged, and therefore comply with the request of this challenging party, or whether they have the strong position and say, no, we continue to go that way, although we know about the legal uncertainties. Beside these legal uncertainties, there are also some other new pitfalls. And of course, these are technical failures during the hearing, and that is not only the CAT filter, which I mentioned at the beginning, but it can be almost everything. It can be problems in the use of the chosen platform, such as technical problems. For example, we had this in a case where we realized that it is very difficult when you use Microsoft Teams to present PDF documents to the other parties. And in that hearing, all exhibits had been submitted as PDF documents, and it was all parties' expectations that these exhibits would be presented to witnesses and to the arbitrators during the hearing. So there we made a last-minute change from Microsoft Teams to Zoom, simply because it is much easier to present documents that are not Microsoft documents in Zoom. It can be personal problems, such as you don't know how to share your screen, and or you have problems with filters. It can be unstable internet connection. It can be automatic updates or failures of your computer during the hearing. In particular, these automatic updates, at least it is my personal experience, you cannot control when they pop up. And if you have to tell your computer every 15 minutes that it shall not restart now, it can be quite annoying during a hearing. It can be disadvantages appearance in the chosen setting. That can be virtual or real backgrounds that do not really fit to the situation you're in during that hearing. I watched some parts of the exit case Vattenfall against Germany, and I was a bit surprised that some of the experts in such a large-scale hearing, when they were interviewed in that virtual hearing, it looked like they were standing in their kitchen or in their living room, and I thought, well, that does not really emphasize the professionality of this expert. So be careful what you, or be aware of this when you decide to do a virtual appearance in the hearing. You should also check your sound quality, the camera quality, whether the lighting conditions are appropriate, that you can be actually seen when you want to be seen. And then it is a bit more general. It can also raise credibility issues for experts and witnesses because you don't see the expert sitting in the same room or the witness. There's always the risk whether the witness has some other line of communication open. You can have chat programs on your screen which no one will see because the camera is facing you. And you can take that to the extreme. I know of one case where I was not involved, but colleagues of mine, the opposing law firm had sent lawyers or other representatives in each room where witnesses were sitting for their virtual testimony, just to make sure that they were not having other lines of communication open during the testimony. That is, of course, it is this extreme, but if you don't do it, it requires a certain level of trust. You can somehow control it, and that is what we did in the hearing we had in March, that at the beginning of the hearing, the witness takes his camera and moves it once around in the room, that everyone can see what is in that room. But I can't control whether after he did so, he opened some chat program on his screen. It's a level of trust that is required in that moment. Potential solutions for it, well, we are still in an early phase, but we have seen a lot of best practice guides popping up for protocols on virtual hearings. Just very recently, the IBA revised its rules on the taking of evidence in international arbitration, also addressing protocols for virtual hearing. I have reviewed it yesterday. It's a very high level, but to my experience, very similar to the best practices that exist so far. So on how to address technical failures and potential alternatives upfront before the hearing, conduct test runs with the tribunal, but also internally with the witnesses to be heard, have essential participants dial in at least 10 minutes before the planned beginning. This is just, it's all minor things, but you can do them to limit the potential surprises during the virtual hearing. And maybe as a last advice, prepare as diligently as for any physical hearing. And that takes back the link to the CAT filter. I think everyone would check his back before you go to court, whether you have indeed put in your robe and not your kid's bunny costume. And if you would do that with your Zoom filter before the hearing starts, you would realize that you appear as a cat. So maybe that is an advice for everyone, that virtual hearing is as serious and should be as prepared as diligently as any other physical hearing. And I saw this picture and just want to share it with you. This having been said, this is how your desk could look, at least as a lawyer, during a virtual hearing. You should be able to multitasking. Thank you very much.
Thank you very much, Jörn.
Thank you, Jörn and Chris, for this very thought-provoking and interesting presentations. I think with this "I'm not a cat, I'm a human" situation last week, our webinar was just spot on time. Chris, thank you very much for this very interesting summary of the ICA analysis on the right of the physical hearing, in particular when it goes to some differences among the jurisdictions. As you mentioned, we're still waiting for the ICA report on Poland, which should be released in the next round. We're really looking forward for it. And we will see how the situation looks in Poland. Before our webinar, I looked into some data, and apparently when it goes to the case law in court at the PCC, last year in 2019 there were 0 virtual hearings, while in 2020 44% of the cases were held, the hearings were held remotely. Of course, we're looking at 2020, so the year of the COVID-19 and the new reality, we were all getting used to it. But it seems that there will be more and more cases where the right to physical hearing, or what Jorn related, all the issues to the questions of the due process concern, will definitely become an issue as we will have more and more cases. There are, again, legal uncertainties, as Jorn mentioned, and from my perspective, the most important are the data protection and also the cybersecurity. And there is a huge space for using those as a part of the guerrilla tactics. But there are also, as Jorn mentioned, some issues, some actions that can be taken in order to mitigate the concerns as to the vulnerability of the virtual hearings. And preparation is the king. So it's one of the possibilities. We have some guidelines to help us to tackle the problems. There are ICA protocols on the data protection and cybersecurity. And also, for instance, maybe the solution is to think in the hindsight and to include a specially tailored arbitration clause in the agreement already that foresees the possibility of the virtual hearings. I believe that giving the upside, all the upsides that Jorn mentions, and I'm not talking here about the hearings which involves the participants in the different time zones, but the saving on costs and the time, and which allows us more flexibility. I believe that the virtual hearings are here with us to stay, especially in particular, maybe for a significant portion of cases. At least the feedback that I have received from participants of the virtual hearings was very positive, including myself. We have, as Jorn mentioned, the IBE rules recently updated with the remote hearings definition there. So it seems that they're here to stay. But we would like to also ask the participants about to this webinar, what are their opinion about it. And before giving the floor to the questions, and I know there are some, we would like you to ask the participant to partake in a poll, which Agnieszka mentioned at the beginning. I think you should see the question on the screen shortly. Yes, so there are 3 questions we would like you to take a moment and to answer. And the first one is, what is your experience with the virtual hearing this far? The second is, what is your preference for the future cases, whether you want to go back to pre-COVID-19 style, you would prefer to have entire arbitration to be virtual, or as we have now our webinar, as Christopher mentioned, a mixed one. So the entire arbitration be virtual, but with except for the hearing. And the last but not least, the question is, do you think you would recommend inclusion of in the arbitration clause that the arbitration be online virtual? And I think we will give a little bit time to partake in the poll. We still have Agnieszka. You think we can see the?
Yes,
Yeah.
let's wait a bit more, because
60%.
60%. Okay, I don't see the percentage, so you need to help me with this one. This is one of the virtual reality requires more collaboration.
9 people left to I don't know if they are trying or not.
Because maybe
Yes. 8.
It's a countdown.
6. You have to vote too.
Oh, yes, of course.
And it's important to click submit if you've done your voting. So not only.
I forgot that also. Okay.
To fill some time, I just wanted to comment on the court in the cat video. And I think it's just the whole experience that during COVID that has normalized virtual hearings. I agree that you'll see it, in the future, even after COVID, it's not as if the courts are going to say, oh, crisis over. You can't have virtual hearings anymore. I think in appropriate situations, you'll still have virtual hearings. And the court in that cat video was just so cool. He didn't break down or anything. It was just, I think we have a filter problem. You might want to check that. So the courts and the arbitral tribunals have gotten very tech savvy. All the generations.
Yes,
Interesting.
I agree.
They were trying to help this poor lawyer to turn it off. That was very nice of them.
So I think we should have the result before we get to the questions.
We have.
Okay. I think
we can.
We can
end the poll.
And the poll. Okay.
We haven't voted. That we stop the polling. And I'll share the results.
Yes. So 79% has a positive experience. 53 still would go to the mixed one. So the entire arbitration, the virtual, except for the hearing. And 41% of the respondents find that it depends on the contract and who the parties to the contract are. So that's a very interesting result. Thank you very much for participating in the poll. And now we still have 11 minutes for the questions. So Agnieszka, I will give the mic back to you and to the audience. Thank you.
Thank you, Anna. Yes, indeed, we have very interesting questions here. So maybe I'll start from the first one, which was by Joanna Kolber, and she asked, has any case law been rendered already by Polish courts regarding virtual hearings? Similar to the judgment of 23 July 2020, the Austrian Supreme Court, which expressly considered the virtual hearings are generally allowed under Austrian arbitration law. And as Anya already said, I think it's, I haven't heard about Polish case law till now, because I think it's quite early yet, but
Polish court, for sure.
yes. And a Polish court, it's even because I think the arbitration virtual hearing was a bit earlier even than Polish courts. So no, that I think that there is no about which we know, but of course we can check it after webinar also if anything changed. So.
Agnieszka, about just roughly from your offhand. I guess what percentage of hearings during COVID have been virtual and which have been live in the courts, your court experience?
44%.
Yeah.
In 2020, it was 44% of the hearings were held online. That's the data that I checked.
Yeah, and it was really visible the change, yes, because we started with really the parties were a bit shy with virtual hearings, and after first procedural hearing, only just to let's try it and then we will see, and now it's like 45-50%, and I think it's growing.
Yeah, it's growing, and at the beginning they were all trying to postpone hearings because they were thinking that that I don't know, COVID will pass sooner and we will have an opportunity to meet here in a court. But now all of the people agree that there will not be a very fast change in the situation. So they are really, I think that they agreed that this is the good solution. And I think that there is a big growth of trust, that people trust each other and they think that they have concluded virtual hearings without being afraid of technicality and witnesses. Yeah.
Okay, so the second question from Jana Kolber is that to Jörn and his presentation different about different time zones. And I guess that there are never fully satisfactory solutions to difference in the time zones. For example, in physical hearings, one of the parties may be forced to plead the case with a gigantic jet lag.
And yes, of course, if you have different time zones, that will always be a problem for at least one of the parties. But when you have a physical hearing place, then there will not be much debate on what time zone you start and end the hearing, but it will be the time zone where the agreed place of the hearing is. And if it's a really big case and you are the party traveling to the place of the hearing from a different time zone, you might in practice think about going there 1 day or 2 days earlier to at least work a bit against the jet lag that you will otherwise have. While when you do it remotely, I think it is more difficult to say, okay, we do it in this time zone because the other party would then have to do it during their night shifts. But of course, the problems are similar. And I just wanted to address this because it came up in our case, and there the agreed solution was to only start at, I think it was 1 o'clock and conduct the hearing until 9 in the evening. Maybe it also addresses a bit. I saw the next question from Agnieszka is whether we will continue to have long hearing days when we use Zoom. In that case, we did, and it was the sole arbitrator who said no, he agrees to it. But you're right. The question is in particular to the arbitral tribunal, because counsel can usually work in teams and therefore can split the work between them. I think if you do sufficient coffee breaks and lunch breaks, it is possible to have an almost normal hearing day also via Zoom. But you're right, it is a bit more difficult.
Thank you, Jörn.
Okay, thank you very much. We got 10 questions, so a lot. So let's move to the next question. We got a question from Alicja Zielińska-Eisen. Thanks, Alicja, for joining. How far does the equality of parties treatment goes when it comes to virtual hearings? For example, is it possible for one party to participate from one location if the other party cannot or will not assure such hybrid format on its end and needs to sit separately? This is one question. And another question from Alicja, I guess to Jörn, picking up on Jörn's presentation, can you really do the usual 9 to 6 hearing schedule virtually? So who would like to address the first one?
I think that Chin is typing.
Okay, Christopher is typing the answer.
No, I was just going to say. I mean, I think the equality is
okay.
You know, as you say in the Polish, you know, the legislation and under the SAKIG rules and the rules of most institutions, you know, you have to ensure that the parties are treated equally. You know, at the same time, you can't allow one party to sort of dictate whether or not you have a virtual hearing. But I think in some cases, if it's going to be virtual, then, you know, it may be better to have a virtual hearing for everybody, rather than having, there would be some dangers of having a tribunal in a room with one party, but not in the room with another party. So, clearly there are dangers in virtual hearings, and you just want to make sure that the basics of due process are covered.
I totally agree to Chris, and the easiest way is to address these issues up front, talk about it. So in two hearings that I had, it was not about sitting in the same room with the tribunal. I think that is maybe another point, but there was the question whether the party representatives of our client would be allowed to sit in the same room with us, and we addressed it openly, and opposing counsel simply agreed to it. So I think it is important to address this, and not simply to act in the one way or the other. If it really comes down to a conflict that one party says I want it and the other party says I don't want it, probably as an arbitrator, I would tend to say both parties should do it the same way because of equal treatment. But you have to be very careful with it, because on the other hand, it can be raised, it could be challenged by not granting full right to be heard, as the party is not in the same room with their legal counsel. So that it is a tricky issue, and I don't have a perfect solution for the case that the parties really disagree. And my advice would be to try to seek agreement on that and address it up front.
Okay, thank you very much. And getting back to Alicia's question, can you imagine the usual 9 to 6 hearing schedule?
I think I addressed it in my previous answer, and I would say, in principle, yes. It is upon the tribunal to decide, and maybe the older the tribunal, the more questionable it is. So it might be a chance for young arbitrators to position themselves in the market as being able to work longer on the computer and Zoom. But yes, you definitely have to.
Well, let's not be ageist. I think I've
You're
seen
still young.
I've seen older arbitrators with their Red Bull in their briefcase. Caffeine does wonders.
It will be on the tribunal to decide, I think. And if they say, well, yes, it works, and just do sufficient breaks, then yeah, I think it is possible in principle.
Okay, so my apologize for posing this question twice to you. We have a question from Weronika Redzińska-Zowczak. Would you mind?
Oh, I like this question. I saw it. Veronica was asking, well, what about the eye rolling? I guess one party challenged that in court, and that goes to the whole question of whether, now that we have a video record of the hearing, you not only have the written transcript, but you have the actions of the witnesses and the facial expressions.
And do you think that may be an increasing trend concerning the challenge of arbitrators, or is this the biggest threat associated with online hearings to arbitrators, or there are more serious risks? This is the question from Veronica. Chris, do you hear me?
Yeah, I think there's I don't see an increased possibility for challenge, and in fact it might dissuade challenges, in that you not only have the written transcript of what happened, but you have the video. If anything, it will discourage arbitrators from falling asleep during hearings, which happens apparently. I've not encountered that, but that would be regrettable.
Yeah, and do you think that the solution could be the amendment of the IBA guidelines, or some protocol, or maybe during the hearing? how to avoid this kind of challenges.
I think it is probably not necessary to amend the guidelines here. What should you write in it? That it is okay that the arbitrator rolls eyes? That probably will not work, because it could be a sign of lacking impartiality, but I think it is more about a practical approach to it, that you should somehow transfer what you have already established on certain statements by arbitrators during hearings, and that a strong statement is fully okay if it fits to the situation, that you adapt that to the appearance.
Okay.
Okay. We have a quick follow-up question from Joanna Kolber, Australia, Brussels. What was the attitude of Polish state courts to virtual hearings? That's a tough question, but perhaps Anya, could you address it?
Well, during the pandemic, the courts tried to accommodate the need and to conduct the online and virtual hearings. From what I've heard and the experience that I have, it depends on the court and it depends on the judge. It depends on the technical preparation that it's available for the court. And as far as I know, if the technical solutions are there, there is no problem, and some of the hearings are now being held virtually via Zoom, and there is not a problem with that. So I think it really depends on the particular court and available solutions. But we don't have yet the at the post hearing we don't have the court's position on the post arbitration matters, because it's still, we need a little bit more time to get that experience.
Okay, thank you very much. To what I know, Anya litigates a lot in Polish courts, so that's why I asked her. I asked her to answer this question. And now we got another question.
Yes, from Agata Zolankiewicz. I think Jörn has already addressed it in his when he mentioned about the time of hearing and the younger arbitrators. So Agata Zolankiewicz is asking, do you think that if virtual hearings are here to stay in the post-COVID era, would that impact the profile of prospective arbitrators? Would that open new possibilities for younger arbitrators who are perhaps more comfortable with technology? I think that we have already mentioned it, but maybe Jörn, would you like to add something?
Yeah, I think it is possible, and in particular for maybe smaller cases. I think for the really big cases, the parties still want to go for the big names as arbitrators. But when you say, well, this is a case that will probably go well virtual, and you are maybe in principle already open for a younger arbitrator, then this can be just another additional argument to go for a young arbitrator in that case.
Thank you for, maybe I would add only that from a court perspective, it not depends on maybe age, but attitude. I would say that there are arbitrators who are really keen on and want to try it, and they are really good at in virtual hearing, and also there are young that really are not keen on and think that it's not something they want to do, and really ask, well, I would prefer to see face to face with this witness. So and it's really not about age, but about attitude. So that would be our perspective from the court, yes, and we organize that. hearings.
We're running out of time, but we've got still two questions that we would like to cover. First, we have a question from Maciej Durbas. Maciej is asking about the CAD video. He says that the CAD video dragged attention to e-hearings. It was hilarious and thus not negative. Things will not go so smooth if the data from an arbitral e-hearing would be compromised and sold in the dark web. The arbitration community probably cannot avoid such situations. And here the question, what can we do as a community if it happens to save our reputation? What do you think? Who would like to address this question?
Maybe just an initial thought on it. Yes, there is this risk, and I totally agree that this CAD video was not negative at all, and the other outcome could be. But this risk, to a certain extent, it already exists now, because the transcripts of a hearing, they are usually transferred by email, or at least they are electronic files, and they are somewhere on the service of the participants of the hearing. So the risk that a hearing protocol is somehow leaked and sold in the darknet already exists, and that I struggle to see why it should be so more damaging if it would be a video instead of the transcript. So I think that the risk is not so new compared to the current situation. But on this being said, this risk is a big risk to arbitration in general, and therefore I totally recommend that you put in cybersecurity orders and guidelines in the POs or in the arbitrator contract, and that you do all you can to avoid it from the outset. And if it happens, well, maybe if you want to defend e-arbitration, then you simply could say could have happened also with the result of a normal arbitration. It then goes maybe more in general, what can arbitration do in case of such leakages?
It might also be something positive. I mean, as we've seen in some, well, in investment arbitration, where the hearings are more public, commercial arbitration is generally private, and oftentimes the proceedings are confidential, but there might be, to the extent that certain important cases might be made public, there's a potential for positive press as well as negative press, that, people, everyday people aren't necessarily aware that arbitration hearings are going on, that they're parallel to the court system, and that they're a major way of resolving disputes between private companies, whether domestically or internationally. So maybe this is our chance to make a positive publicity as well.
Thank you. There are two more questions from Professor Maciej Zachariasiewicz. The first one is, what if one of the counsel witnesses is unable to connect via video, but we can hear audio? If she agrees to participate in that manner, there is no problem. But what if she objects? May the tribunal continue with the hearing? This is the question.
It depends. Right?
Perfect answer. Yeah. It depends.
Gentlemen,
Yeah.
one.
Maybe just one additional. I think that really goes to the question of equal treatment. If one party or one witness can only be heard and not be seen, that and objects to continue the hearing in this way, I would tend to stop the hearing, or at least make a break and do everything to somehow reconnect or to reconvene at a later stage when that person is maybe at another computer or at another place. Because as long as it is not willful jeopardizing the proceedings, then this will go to the core of equal treatment. I think if you just hear one person and see all the other, that doesn't go well.
Yeah, I think there's a difference between what a tribunal might be permitted to do, and what a court might ultimately find is adequate equal treatment, and then also what a tribunal should do to promote the general feeling among the parties that in fact that they are being treated fairly. So yeah, I think the fact that one party isn't able to be seen on video, that could make a difference. Maybe not on challenge proceedings, but in terms of best practice, you want to make sure that everyone gets at least an equal shot. But of course, if one party is trying to jeopardize the hearing by creating technical difficulties, that's another question.
And what the court can do, we are trying to test our connection before the hearing, so that there will be no technical troubles. And the other way, which we are trying to make it easier for the witness to connect, that we have agreements with the regional chambers. So if the witness is not being comfortable with the Zoom and all the technicalities, he is able to just come to the nearest chamber of commerce, regional chamber, and the staff which is in the building is an IT team able to help to connect. So it's this kind. It's also, let's say, technical, but support to.
That's right. And in the SAKIG virtual hearing that I was involved in recently, I know that the court made it a point of having a test run with all of the participants, which was good. Also, it saved time. It made everyone feel comfortable, and it was also a way of so I guess visual communication. Even if nothing was said, it's another chance for the parties to meet face to face with their dispute.
And the second question from Professor Zachariasiewicz is to Anna Tujakowska concerning the pool. What exactly do you mean by mixed? The entire arbitration be virtual, except for the hearing arbitration?
Well, that's you will have the procedure meetings and the procedure, the hearings pertaining to the procedural issues will be held online. There is no need to meet in person. However, when it goes to the hearing, you will have to have people and the participants, including witnesses and experts, in the one place. So that's one of the ways that we believe that it might be how the future might look like. That for some, as we know from the pool, there is 3% of participants had a bad experience with the virtual hearing thus far. So I would assume that this 3% might opt for arbitration proceedings be held virtually, except for the hearing. So the hearing will be in a traditional post-COVID-19 way.
Okay, thank you very much, Anya. And we've got a final comment from Joanna Kolber. Regarding daily duration of the virtual hearings. She says, I believe the general advice would be to have 5-6 hours of virtual hearing per day. Well, sounds very reasonable, I think. And this is the last comment, the last question that we've got on our list. So I think it's time to sum up our webinar. Anya?
I believe, as I said at the wrap up before, I believe that this is a new reality which for some will be reality, not a new one, but reality. For this year, Vismut problems included the question of the due process in the light of the virtual hearing. So it's here to stay. Once again, Christopher and Jorn, thank you very much for extremely interesting and thought-provoking conversation. We it's 11:17, so we stretch a little bit time of our webinar, but we had so many questions that we could not just simply leave them unanswered. We will come back to the participants with the results of the poll, which will be, as Agnieszka, I'm sorry, explained, will be published on the LinkedIn. And thank you very much for all the participants to taking a cup of Friday's cup of coffee with Kik and AFM below 40. And I hope to see you all in our following webinars in the following months. So have a great Friday, and thank you very much.
Thank you.
Thank you very much.
Thank you.
All of you.
Thank you, everyone.
Bye-bye.
Bye.
Thank you.